Hey there, friends. Very interesting topic that I want to talk about today, sent to me by my friend John Crump. I've often talked about how felons, once they've served their time, should have the constitutional right to keep and bear arms. The Constitution states that. It does not say that once you've gone to prison and gotten out and done your time, you still can't have your firearms. Interesting case just happened. On June 6, 2023, the United States Court of Appeals for the Third Circuit in the case Range versus Lombardo issued an opinion stating some felony convictions are not sufficiently based on the historical record to take away rights protected by the Second Amendment. The opinion was agreed to by 9 of the 15 judges in the circuit. Now, before we get too much more into this, I want to give a little bit of backstory on this. This is really a pathetic way that this guy was prevented from having firearms to begin with, regardless of the whole felon story. Here's some of the details. In 1995, Mr. Range pleaded guilty in the Court of Common Pleas of Lancaster County to one count, get this, of making a false statement to obtain food stamps in the violation of Pennsylvania law. In those days, Range was earning between $9 and $9.50 an hour as he and his wife struggled to raise 3 young children on $300 per week. Range's wife prepared an application for food stamps that understated Range's income, which she and Range then signed. Though he did not recall reviewing the application, Range accepted full responsibility for the misrepresentation. Range was then sentenced to 3 years probation, which he completed without incident. He also paid $2,458 in restitution, $288.29 in costs, and a $100 fine. Other than his 1995 conviction, Range's criminal history is limited to minor traffic and parking infractions and a summary offense for fishing without a license, another victimless crime. Now, this is where it gets a little goofy. When Range pleaded guilty in 1995, his conviction was classified as a Pennsylvania misdemeanor punishable by up to 5 years imprisonment for a misdemeanor. That conviction precluded Range from possessing a firearm because federal law generally makes it unlawful for any person who has been convicted in any court of a crime punishable by imprisonment for a term exceeding 1 year to possess or affecting commerce any firearm or ammunition. Yeah. We got Hunter Biden over here doing his thing. And this man, because of information to get food stamps, prevents him from purchasing a firearm. And he gets a suspended sentence, of course. He did not spend time in prison, but could have spent as many as 5 years in prison for signing a document that said he made more money than what he actually made. So that gives you the backstory. So here's the majority opinion. Brian Range appeals the district court's summary judgment, rejecting his claim that the federal felon in possession law violates his Second Amendment rights to keep and bear arms. We agree that Range, that despite his false statement conviction, he remains among, quote, the people protected by the Second Amendment. And because the government did not carry its burden of showing that our nation's history and tradition, there's that beautiful phrase again, of firearm regulation support disarming Range, we will reverse and remand. Then while all this stuff was taking place on Mr. Range, the Bruin decision came out. They state that a panel of this court affirmed the district court's summary judgment, holding that the government had met its burden to show that 922G1 reflects the nation's historical tradition of firearm regulation such that Range's conviction places him outside the class of people traditionally entitled to Second Amendment rights. Really? Well, guess what? The Bruin standard does apply here. Range's appeal instead requires us to examine who is among, quote, the people protected by the Second Amendment. The government went on to state that Range claims he is one of, quote, the people entitled to keep and bear arms and that our nation has no historical tradition of disarming people like him. The government responds that Range has not been one of the people since 1995. This is when his conviction was, when he pleaded guilty in Pennsylvania state court to making a false statement on his food stamp application and that his disarmament is historically supported. Okay, that's bullcrap. And luckily they went on to talk about, and this was interesting to me, other places in the Constitution that they actually talk about the people and whether or not those rights should be restricted as well. They state that the people, as used throughout the Constitution, unambiguously refers to all members of the political community, not an unspecified subset. They go on to state that other constitutional provisions reference the people It mentions the people twice with respect to voting for Congress, and the people are recognized as having rights to assemble peaceably, to petition the government for redress, and to be protected against unreasonable searches and seizures, unless the meaning of the phrase the people varies from provision to provision, and the Supreme Court in Heller suggested it does not. To conclude that Range is not among, quote, the people for Second Amendment purposes would exclude him from those rights as well. Now, so far, this is very well written. This is telling a story. This was not, they didn't come up with this in a back room over a couple of beers and smokes. This was pretty well done. They go on to state the phrase law-abiding responsible citizens is as expansive as it is vague. Who are law-abiding citizens in this context? Does it exclude those who have committed summary offenses or petty misdemeanors, which typically result in a ticket and a small fine? No. We are confident that the Supreme Court's reference to law-abiding, responsible citizens does not mean that every American who gets a traffic ticket is no longer among, quote, the people protected by the Second Amendment. They go on to state that the government's claim that only law-abiding, responsible citizens are protected by the Second Amendment devolves authority to legislators to decide whom to exclude from, quote, the people. We reject that approach because such extreme deference gives legislatures unreviewable power to manipulate the Second Amendment by choosing a label. That is one of the most beautifully concocted paragraphs, groups of words regarding the Second Amendment that I think I've ever read. It's almost like with the Bruin ruling that now these judges are taking their jobs a little bit more seriously. I think before they were able to just go through and make these arbitrary, stupid little decisions and everybody went along with it. And now everybody is pushing back. I think that these people have figured out that the Second Amendment is not like every other stupid little tabloid topic that people talk about around a water cooler. This is a life-altering amendment that we have, and Americans take this very seriously. And they're making these judges now make educated decisions in cases like this. Finally, they state that our decision today is a narrow one. Brian Range challenged the constitutionality of 18 U.S.C. 922G only as applied to him given his violation of 62 PA statute, whatever. Range remains one of, quote, the people protected by the Second Amendment, and his eligibility to lawfully purchase a rifle and a shotgun is protected by his right to keep and bear arms. Because the government has not shown that our republic has a long-standing history of tradition of depriving people like Range of their firearms, this code cannot constitutionally strip him of his Second Amendment rights. We will reverse the judgment of the district court and remand so the court can enter a declaratory judgment in favor of Range and join enforcement of 922G1 against him and conduct any further proceedings consistent with this opinion. Meaning that Mr. Range will have his constitutional rights restored to him. Now, this case is a little bit different than your normal, quote, felon, simply because he's kind of assumed to be a felon even though he only had a misdemeanor. Because Pennsylvania, and I guess the federal government in this case, see that any kind of potential sentence that was going to be more than 1 year is automatically way worse than any other misdemeanor, which I guess supposedly it could be, but judges are ruling on these things differently, so you can't apply the same standard to all of them. So that would be unfair anyway. But to assume that the rules and laws of a felon or a felony would apply to somebody that has a misdemeanor just because the length of time that he would be sentenced is kind of silly. But I like the fact that they are letting this, even though the government is kind of screwing up on this, because the government probably could have given this man's rights back to him to avoid this argument about felons. Because since the man is not technically a felon, they could have said, well, we're going to make an exception. Since the only reason why he's being precluded from having firearms or buying firearms is because he had a long sentence as a misdemeanor, we're going to go ahead and give him his rights. That would have kept them out of the courts, which is now going to apply to felons. Because now this whole ruling has everything to do with people who have felonies. Now they're going to be forced to look at this and say, okay, so now do all felons, not this man because he was not a true felon, but do all felons going forward now have the right to reclaim their Second Amendment rights that the government stripped from them? I have often said, and I will go down in flames saying this, if a man serves his time, when he gets out, he should have his Second Amendment rights restored to him. Because if he is still a danger, so much of a danger that he should not have his rights, he should not be a free man. There has to be accountability at some level for these judges. These judges, if they're going to continue to let these violent people and aggressive people and dangerous people back out on the streets, they need to be held accountable. If a judge realizes that a guy is still a danger but he wants to let him out, you can't assume the man is suddenly going to follow the law anymore just because there's a law in place that says this man is a felon, can't have a firearm. You have to realize that your role as a judge is, if this person is too dangerous to be out on the street, do not try to take his rights from him. Leave his butt in jail. Leave him in prison. That's where he belongs. I don't want him moved in next door to me with a baseball bat, a knife, or a beer bottle, let alone an illegal firearm that he stole from somebody. I say illegal firearm, I hate using that term, but a firearm that he stole from somebody. When these guys go into jail, it's a game to them because they know how the system works and they know the judges are going to let them off. They go in, they get their felony. They get a reduced sentence. They get out quick. They got their felony, so they got the street cred. But they also can't get firearms. So now we're making felons or keeping felons on the street out there who are unprotected. And guess what? Making them into worse criminals now because they are going to find a way to protect themselves. Even the good people who have gotten out of prison and served their time and are no longer a threat or danger to anybody, they're going to do what they have to do to protect their family. We all will. So you're not going to take that desire to keep his home safe from him just by restricting his Second Amendment rights.
I'm sorry, I thought this was America.